Good morning. I hereby call to order the second meeting of the Pennsylvania Public Utility Commission for the year 2016. Please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Our first order of business is the approval of the minutes, and I will call on Vice Chairman Place, who is the editor.
Thank you, Chairman. I have reviewed the minutes of the December 17, 2015 public meeting and move that they be approved as submitted.
Do I have a second?
Second.
Motion by Vice Chairman Place to approve the minutes for December 17, 2015, with the second by Commissioner Whitmer. Any discussion? No discussion. All those in favor say aye.
Aye.
Any opposed? The minutes will be approved 5-0. This time I will call upon Cheryl Walker Davis, our Director of Office of Special Assistance, to lead us through the agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
May it please this Honorable Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items. Commencing this morning with matters on behalf of the Office of Special Assistance, it is recommended that the Commission adopt the recommendation of the Bureau with regard to the proceeding involving Tawana Lipscomb Burnett versus Philadelphia Gas Works at the top of page 1.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the recommendation of the Office of Special Assistance in the proceeding involving the Citizens Electric Company of Lewisburg and Wellsboro Electric Company petition for amendment of the Fourth Joint Default Service Plan, noting the statement of Vice Chairman Place.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Whitmer, and I will call upon Vice Chairman Place for his comments.
Thank you, Chairman. I would like my statement entered into the record as if I had read it in its entirety. Before us for consideration and disposition is the petition for amendment of the Fourth Default Service Plan filed by Citizens Electric Company of Lewisburg and Wellsboro Electric Company on November 20th, 2015, as well as the responsive answers of the Office of Consumer Advocate to the petition. I support our order which approves the amendments to the company's Fourth Default Service Plan, which seeks to make modifications to its original full requirements procurement to remove potential barriers to wholesale supplier participation in the request for proposal. These modifications were deemed necessary in light of the original failure of the previous year's RFP, which only garnered 2 wholesale bids, one short of the required 3 bids necessary to enable approval of the bid results. While I fully support these DS plan modifications, I would also like to encourage the parties to consider examination of the minimum of 3 qualified bidders requirement. The Commission had previously considered a petition by the companies to reduce this requirement to 2 qualified bids. However, this petition was filed at the last minute and didn't provide adequate time for review, as noted in the order which rejected this modification. Going forward, the parties may want to consider the more relevant issue that the bids are just and reasonable as determined by the auction monitor or by company-issued pre- and post-bid reports that examine the fundamental cost elements of the procurement to determine if the bid results reflect the underlying cost of electricity supply and or transmission. In summary, the number of bids may not be the best just and reasonable litmus test. We could have 3 or 4 bids, but the underlying bids may not be reasonable relative to the fundamental cost elements. On the other hand, we may receive 2 very aggressive bids that are affirmed as just and reasonable based on pre- and post-bid cost analysis. Therefore, I encourage the parties to examine the DS plan design element in order to increase the efficiency and effectiveness of these procurements.
Thank you, Vice Chairman Place. Any further discussion? If none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. The recommendation passes 5-0.
Continuing with matters on behalf of the Office of Special Assistance on page 2 of the public meeting agenda, in the proceeding involving Pennsylvania Office of Attorney General and the Office of Consumer Advocate versus Energy Services Providers, Inc., DBA, Pennsylvania Gas and Electric, there is the joint motion of Commissioners Coleman and Powelson.
Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Whitmer. And under discussion, I would recognize Commissioner Coleman for the joint motion.
Thank you, Madam Chair, and I would ask that our joint motion be entered into the record as though I had read it in its entirety. Before the Commission's initial decision to approve the proposed settlement to resolve the formal complaint filed by the Pennsylvania Office of the Attorney General and the Office of Consumer Advocate against Energy Service Provider, Inc., doing business as Pennsylvania Gas and Electric. PG&E is a licensed electric supplier in Pennsylvania. The settlement proposes to resolve the complaint, which alleges that PA Gas and Electric violated Pennsylvania law, including the Commission's regulations related to its variable rate electric generation services. As one of the settlement terms, PG&E has agreed to pay over $6.8 million in a refund pool, which will provide a funding source for refunds and/or credits to eligible customers. The settlement requires customers who receive payment from the refund pool to sign a release of claims discharging Pennsylvania Gas and Electric from any and all claims arising from or related to the conduct alleged in the complaint filed by the OAG and OCA against the company. Mr. Thomas Sobiek is the lone party accepting to the initial decision and is the lead plaintiff in the federal class action lawsuit filed against Pennsylvania Gas and Electric. The settlement terms related to the release of claims is the subject to his exceptions. Upon review of the record in this case and the applicable law, we propose to deny Mr. Sobiek's exceptions number 2 and 4 for the reasons set forth in the staff recommendation. Exceptions 2 through 4 for the reasons set forth in the staff recommendation. We also propose to deny his exception number 1 consistent with the discussion and clarifications in his motion. Exception number 1 to Mr. Sobiek is focused on the language in paragraph 43 of the settlement, which contemplates the execution of the release of claims in exchange for payment from the refund pool. We disagree that adopting a settlement requiring a customer who elects to receive a refund from the refund pool to sign a release as a condition of obtaining payment is an impediment to the Commission's authority to approve the settlement. First, the parties to the proceeding before the Commission may resolve their disputes according to the terms and conditions that are mutually agreeable as between them. This is entirely consistent with the policy of the Commission in encouraging settlements. Moreover, the quid pro quo involved in signing a release is to resolve the claims as being well recognized in Pennsylvania courts. Secondly, nothing in the settlement or the initial decision suggests or requires that the Commission requires the Commission to adjudicate and/or interfere with private cause of action such as breach of contract. Rather, in adjudicating the settlement, the Commission is adjudicating the complaint brought by the entity designated by statute to represent the customers of public utility service before the Commission against the EGS licensed by the Commission. Furthermore, the complaint being adjudicated includes allegations that the Commission licensed supplier violated Pennsylvania law, including the Commission's marketing and billing regulations applicable to EGSs. Consequently, the Commission possesses the requisite jurisdiction over both the parties and the proceeding and the subject matter of the complaint that the settlement proposed to resolve. Third, the settlement does not compromise any consumer rights to pursue the claims against Pennsylvania Gas and Electric outside the Commission's proceedings. Each customer will have the right to determine whether the conditions of obtaining payment from the refund pool are satisfactory in order to resolve his or her claims against the company. If a customer is not willing to resolve his or her claim under the settlement terms and conditions, the customer is free to pursue other rights against Pennsylvania Gas and Electric. For these reasons, we believe the Commission has the authority to approve the settlement. Also, our joint motion proposes to modify the settlement obligations of the Office of Attorney General and the Office of Consumer Advocate by requiring them to provide a specific notice to customers who elect to receive payment from the refund pool. Therefore, we move that the exceptions filed by Thomas Sobiak be denied consistent with this motion, the initial decision be modified consistent with the clarification in this motion, and that the Office of Special Assistants prepare a tentative opinion in order approving the proposed settlement as in the public interest consistent with this motion.
Thank you. You've heard the joint motion as read by Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Whitmer. Any discussion on the joint motion? If none, all those in favor say aye.
Aye.
Any opposed? The joint motion passes 5-0. Now on the staff recommendation as amended by the joint motion, if there's any further discussion. Seeing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It should be noted that the remaining item on page 2 involving the formal complaint of Robert Sarver versus Barnes Professional Limousine Service, LLC, has been postponed until public meeting of February the 25th. Starting on page 3, continuing with matters presented on behalf of the Office of Special Assistance, it's recommended that the first 2 items involving the formal complaints of Mickey Schreiber versus Respond Power, LLC, and Benjamin Israel IMB Real Estate LLC versus Pico Energy Company, and the recommendations there appearing be adopted by the Commission.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second?
Motion by Commissioner Powelson, second by Commissioner Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
With regard to the formal complaint proceeding involving Antonio Romeo versus Pico Energy Company, there is the motion of Commissioner Whitmer.
So I have a motion to call up the staff recommendation for consideration.
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Powelson. And under discussion, I would recognize Commissioner Whitmer for her motion.
Thank you, Madam Chair. I'd like my motion entered into the record as if I had read it in its entirety. Before the Commission today are the exceptions of Antonio Romeo to the initial decision of Administrative Law Judge Elizabeth Barnes. Mr. Romeo filed a formal complaint alleging that PICO was threatening to terminate his service because he refused to allow access to his meter so that the company could install a smart meter. Mr. Romeo alleged 3 things. 1, the smart meters cause fires and serious health and safety issues, as well as privacy concerns. 2, PICO's conduct was in violation of the Federal Energy Policy Act of 2005. And 3, that he has neither denied PICO access to his meter for the purpose of reading the meter, nor is his account in arrearage. Mr. Romeo requested that the Commission order PICO to refrain from shutting off his electric service and to cease attempts to install a smart meter on his property. PICO filed preliminary objections and sought dismissal of the complaint for legal insufficiency on the grounds that Act 129 and the Commission's order approving PICO's smart meter installation plan do not allow for an opt-out provision. The ALJ granted PICO's preliminary objections, finding that there were no disputed questions of fact and that the Commission does not have authority, absent a legislative directive, to prohibit the company from installing a smart meter. The complainant has only one exception before us, which is that the ALJ failed to consider his federal preemption claim. Given that the ALJ did not consider at length Mr. Romeo's federal preemption challenge, I believe that the initial decision should be modified consistent with our staff recommendation and prior Commission orders to include a discussion and legal determination explaining why PICO's mandatory installation of smart meters is not in violation of the Energy Policy Act of 2005. I also do not support the referral of this complaint's health and safety concerns to our Bureau of Investigation and Enforcement for 2 reasons. The first being that Mr. Romeo's exceptions are limited only to the legal question of preemption and do not encompass the health and safety concerns alleged in his complaint. And secondly, our prior referrals of this issue to I&E are sufficient. Specifically, we have recently referred several cases involving similar allegations to the Investigation and Enforcement Bureau for their review and discretion to take whatever action may be appropriate. Accordingly, additional referrals of the same or similar allegations would be duplicative and are therefore unnecessary. Moreover, absent legislative action, the Commission does lack the authority to prohibit a company from installing a smart meter and thus lacks the ability to grant the complainant the relief that he seeks. Therefore, I move that the initial decision be modified consistent with this motion and that the Office of Special Assistance draft an opinion and order consistent with this motion. Thank you, Madam Chair.
Thank you. We have the motion of Commissioner Whitmer. Do we have a second?
Second.
Second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the staff recommendation as amended by the motion, any further discussion? If none, can we take the previous roll call? The motion as amended by the staff recommendation as amended by the motion passes 5-0.
In omnibus fashion, it is recommended that the Commission adopt the recommendations, commencing with that appearing at the top of page 4 in the matter labeled Investigation upon the Commission's own motion regarding a PennDOT application, continuing with the remaining items on page 4, as well as the item appearing on page 5 pertaining to Verizon North LLC and Talk America Services LLC joint petition for approval of an interconnection agreement.
Do we have a motion to adopt the staff recommendations?
So moved.
Do we have a second?
Second.
A motion by Commissioner Powelson, second by Commissioner Whitmer. Any discussion? If none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Bureau of Technical Utility Services, it is recommended in omnibus fashion that the Commission adopt the recommendations, commencing with that appearing in the application proceeding of Bartel USA, Inc. at the top of page 6, and continuing with the remaining items on pages 6, 7, 8, and 9 through and including the matter labeled Letter of Notification of Metropolitan Edison Company at the bottom of page 9.
Do I have a motion to accept the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
On behalf of the Law Bureau, it is recommended that the Commission adopt the Law Bureau's recommendation in the proceeding involving the implementation of the Alternative Energy Portfolio Standards Act of 2004 and the the recommendations to revise the net metering, interconnection, and compliance provisions of the Alternative Energy Portfolio Standards regulations, noting the statements of Vice Chairman Place, Commissioner Powelson, and your statement, Chairman Brown.
Do I have a motion to adopt the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Powelson. Under discussion, I will call on Commissioner Powelson for his statements.
Thank you, Madam Chairman. Before the Commission here this morning for disposition is the final rulemaking order updating several of the Commission's regulations implementing the Alternative Energy Portfolio Standard of 2004. While the order disposes of several issues pertaining to the While the order disposes of several issues pertaining to the APS Act, the provisions updating our regulations on net metering have been particularly contentious. And I think this is unfortunate when you consider that PA was one of the early adopter states in the nation for net metering programs. I firmly believe here this morning that all the new regulations contained in the order being voted on today are much needed consumer protections, particularly the 200% limitation on systems that are eligible for net metering and the clarification of the definition of virtual meter aggregation. These regulations are narrowly tailored to balance the Commonwealth's policy of promoting the development of renewable generation sources with the Commission's mandate of maintaining affordable, reliable electricity service for customers. Further, I do not believe that these regulations impose any unreasonable burdens on the responsible development of renewable generation sources here in the Commonwealth. It is worth noting the lengthy input process the Commission has undertaken while considering these proposed reforms. In fact, on February 20th of 2014, the Commission first asked for comments on the proposed regulations. Due to intense interest in this matter, the Commission extended the initial comment period to ensure that all interested stakeholders had an opportunity to be heard on this matter. After carefully reviewing all of the comments submitted in response to our proposed regulations, the Commission made further changes to our proposed rules and solicited yet another round of comments to ensure that every stakeholder's voice was adequately heard. An almost unprecedented number of stakeholders from diverse industries provided input to the Commission on every single comment was carefully considered. As a result of that input, I believe that the regulations set forth in this morning's order appropriately balance the interest of all stakeholders, including those in the agricultural community. It is important to note that the reforms contained in the new regulations are not occurring in a vacuum. Similar discussions are occurring nationwide as the need to revisit net metering is being discussed in state capitals across the country and also by state commissions, and more recently in states like Nevada and Arizona. As outlined in the order, these new regulations are less restrictive to those found in many other jurisdictions. Just as those other jurisdictions are considering these reforms, the Commission could not stand by and ignore issues that have been created from the absence of firm rules governing net metering. I think it's also important to note that the United States Congress has extended the 30% federal investment tax credit, which will continue all the way out to 2021, which is another sign of continued support for renewable investment across the 50 states. And lastly, I want to recognize the legal team here at the Commission and our technical staff, in particular Chris Brown from our Law Bureau, for their outstanding work in crafting today's order. The order is balanced, it's clear, it's well written, and which is certainly not an easy task considering the numerous competing comments, and the staff should be commended here this morning for this work product. Thank you, Madam Chair.
Thank you, Commissioner Powelson. Recognizing Vice Chairman Place.
Thank you, Chairman. I'd like my statement entered into the record as if I'd read it in its entirety. At the outset, I would also, echoing Commissioner Powelson's comments, congratulate our staff on the thorough analysis of the competing issues contained within this rulemaking. I agree foremost with the concept enunciated in the rulemaking that the Alternative Energy Portfolio Standards Act and Act 129 must be read together. I agree with the rulemaking's effort to assure that the retail value the customer generator receives pursuant to the net metering requirements of the AEPS Act is also the least cost to the customers over time, as is required by Act 129. However, it is axiomatic that the Commission, as a creature of the legislature, has only those powers conferred upon it by statute. Therefore, I must oppose the rulemaking because I believe that it is going beyond the Commission's authority. I believe that the public, including customer generators and retail customers, would be better served if the Commission were to focus on reevaluating retail value rather than adding further constraints to those already contained in the statutory definition of customer generators. Currently, our regulations provide that the price to compare is the retail value, and I believe that the Commission could facilitate the development of alternative energy and ensure the purchase of alternative energy at least cost to the customer by redefining retail value by regulation. Many of the benefits of net meter distributed generation can be valued through measurable elements and include reductions of the socialized costs of energy and capacity market prices, avoided distribution and transmission investments and line losses, and future ancillary benefits associated with advancements in smart inverters. Further, these benefits include the environmental compliance costs embedded in the price for capacity and energy. On the other side of the ledger, as net metering market penetration expands, there may be a need to account for incremental costs related to high-density deployment of net meter facilities on the distribution grid. Lastly, retail value may be dynamic over time as those costs and benefits are altered by changes in energy demand across the energy landscape. In summary, I firmly believe that consumers are best served by getting the retail value price right rather than by seeking to impose net metering capacity restrictions which are not in the Act. Sufficient market signals exist to achieve both the goal of supporting the deployment of alternative generation as well as the obligation to do so at a cost that matches the consumer benefits of retail distributed generation. This approach is both regulatorily efficient as well as cost effective. Thank you.
Thank you, Vice Chairman Place. I also have comments to put on the record. I want to submit mine to be on the record in its entirety, but I do want to make some comments for your hearing. Want to also compliment the staff. I know Chris Brown, I've called him into my office so many times, he's probably thinking, she's a crazy woman. No, I'm just kidding. But I really struggled with the regulations and trying to understand the part in terms of the cap of the 200%. I know that all these regulations or the proposed changes that we are attempting to make, I agree with Commissioner Powelson that they are there to protect the consumer. I really do. And every time I started my meetings with either Chris or someone else on staff, or even my discussions with Commissioner Powelson, I said, let's start with the proposition that I agree with the regulations in terms of what we're trying to propose. But I could not wrap my mind around, and because of my legislative drafting experience here in the General Assembly, could not connect the dots that would allow us to have the statutory authority in terms of putting that cap in place as we are proposing in the regulations. And because of that, I will be voting no on these regulations. If there's no other comments.
Madam Chair?
Yes.
Can I take an opportunity to associate myself with the comment made by Vice Chairman Place in this whole notion of the retail value proposition? And I think it speaks out to a potential down-the-road conversation that this commission can embark on to get at this issue of retail proposition versus what we're faced with now in the current legislative construct. Mm-hmm. And I want to commend you because this is one of those things, one of these Powelson hangovers I left you, that Chairman Brown walked right into it, and we had some great discussions, and I respect your position on this.
Thank you. And I also respect the comments and concur in the comments that Vice Chairman Place did put on the record as well. If there's no further discussion, we will take the vote. All those in favor say aye.
Aye.
Any
Aye.
opposed?
No?
I heard 3 ayes and 2 noes. That would be Vice Chairman Place and myself as dissenting on this matter.
And turning now to matters presented on behalf of the Office of Administrative Law Judge, commencing on page 11 of the public meeting agenda. With regard to the first matter involving the complaint of Janae Keys versus Philadelphia Gas Works, there is your motion, Madam Chairman.
Thank you. Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Powelson, and at this point I will turn it over to Vice Chairman Place to temporarily preside.
Thank you, Chairman. I would like to recognize Chairman Brown for purposes of her motion. Chairman Brown.
Thank you. On June 12, 2014, Janae Keys, the complainant, filed a complaint against Pennsylvania, the Philadelphia Gas Works, asking for $4,799.93 in liens to be removed from her property. The complaint further alleged that the arrearage on Ms. Keys' deceased great-grandmother's account was improperly transferred to Ms. Keys' new account, even though Ms. Keys did not live at the great-grandmother's property during college. PGW filed preliminary objections averring that the Commission lacks jurisdiction over the subject matter of the complaint. The ALJ held that the complainant must obtain relief through procedures established by the municipal claim and tax lien law. The ALJ granted the preliminary objections based on the lack of Commission jurisdiction and dismissed the complaint without hearing. The complaint shows that in addition to asking that the liens be removed, which I agree is outside of the Commission's jurisdiction, the complainant alleged that she was improperly billed by PGW. The initial decision seems to imply that there may be amounts in dispute that were not the subject of a lien. Given this ambiguity and because the Commission retains jurisdiction over service issues and any outstanding balances that have not been converted to liens, it was not appropriate to dismiss the complaint in its entirety. As such, I wish to remand this portion of the complaint to the Office of Administrative Law Judge for such hearings as may be deemed necessary. Therefore, I move that the initial decision be reversed in part, consistent with this motion, and the Office of Special Assistants prepare an opinion and order consistent with this motion.
Is there a second to the motion?
Second.
Seconded by Commissioner Whitmer. Thank you. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0.
Thank you, Vice Chairman Place. So on the staff recommendation as amended by my motion, any further discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? The staff recommendation as amended by my motion passes 5-0.
With regard to ALJ Buckley's initial decision in the complaint proceeding of Floyd Tillman versus Philadelphia Gas Works, there's a joint motion that you have, Madam Chairman, with Commissioner Coleman.
Thank you. Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
Motion by Commissioner Powelson, second by Commissioner Whitmer. I will recognize Commissioner Coleman for our joint motion.
Thank you, Madam Chair. I ask that our joint motion be entered into the record as though we had read it in its entirety. Before the Commission is the initial decision dismissing the formal complaint filed by Floyd Tillman against Philadelphia Gas Works. The complaint was dismissed based upon the doctrine of res judicata and Section 316 of the Public Utility Code. The initial decision reasoned that the same billing that had been subject of a prior adjudication by Martha Tillman versus Philadelphia Gas Works, which was dismissed with prejudice for failure to prosecute in 2011. Because there are issues raised in Floyd Tillman's complaint that may not have been previously litigated in Martha Tillman's prior complaint, it is premature to conclude that res judicata and Code Section 316 apply here. First, Mr. Tillman's complaint raised a termination of service issue that was not raised in Mrs. Tillman's complaint. Second, based upon the pleadings, the amount of controversy in Mr. Tillman's complaint does not appear to be the same as Mrs. Tillman's complaint. Consequently, the initial decision dismissing the case should be reversed in that the matter should be remanded to the Commission's Office of Administrative Law Judge for further proceedings so that the complainant may have an opportunity to further articulate his claims. Therefore, we move that the initial decision be reversed and the matter be remanded to the Office of the Administrative Law Judge for further proceedings consistent with this motion, and that the Office of Special Assistants prepare an opinion and order consistent with this motion.
Thank you. You have heard the joint motion as read by Commissioner Coleman. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the staff recommendation as amended by the motion, any further discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? The staff recommendation as amended passes 5-0.
It is recommended that the Commission adopt ALJ Heap's initial decision in the complaint proceeding involving Frank Nellum versus Aqua Pennsylvania, Inc.
Do I have a motion to adopt the staff recommendation?
So moved.
Do I have a second?
Second.
Motion by Commissioner Whitmer, second by Commissioner Powelson. Any discussion? All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And on page 12 of the public meeting agenda, with regard to ALJ Dunderdale's initial decision in the proceeding of Lonnie Durante versus Blue Pilot Energy LLC and PPL Electric Utilities Corporation, there's a joint motion, Madam Chairman, that you have along with Commissioner Coleman.
Do I have a motion to call up the staff recommendation for consideration?
So moved.
Do I have a second?
Second.
Motion by Commissioner Powelson, second by Vice Chairman Place. And at this time, I will turn it over to Vice Chairman Place to temporarily preside.
Thank you, Chairman. I would like to recognize Chairman Brown for purposes of her motion. Chairman Brown.
Thank you. I will submit the motion in its entirety and summarize it for your hearing. Before the Commission is the complaint of Lonnie Durante against Blue Pilot Energy, alleging that there were incorrect charges on her bill. By initial decision of the ALJ, concluded that the complainant did not meet her burden of proof to show that Blue Pilot is responsible or accountable for the problem described in her complaint. Consequently, the ALJ dismissed the complaint. Upon review of the proceeding, we disagree with dismissing the part of the complaint addressing electric supply charges for February 2014. Nevertheless, we wish to highlight a concern of ours with dismissing the complaint in its entirety. Specifically, we focus our attention to findings of fact 12 and 13, which exhibit that Blue Pilot offered the complainant a reduced rate, the complainant agreed to the reduced rate, and that Blue Pilot ultimately never provided Ms. Durante this reduced rate. Based on these findings of fact, it is clear that the company did not bill the complainant a rate that matched the rate marketed and subsequently accepted by the complainant. In the initial decision, the ALJ recognized these circumstances but concluded that the Commission could not offer a remedy, stating the Commission lacks authority to order a refund. We respectfully disagree that there is no remedy here. Consistent with the Commission's decision in the case of Herb versus Respond Power case, we submit that the company's failure to bill the complainant at the rate offered and accepted constitutes a violation of our regulations, which mandate consistency among the prices and EGS markets, discloses, and bills. To address this violation, we direct the company to refund the complainant the net difference between the rate charged and the rate agreed upon. This remedy is consistent with the Commission's plenary authority under the Public Utility Commission to order EGS refunds. Last, we remind Blue Pilot that when offering services in Pennsylvania, it must comply with all applicable statutes, regulations, and Commission orders. Therefore, we move that the formal complaint filed by Lonnie Durante at docket number F-215-248-7082 be sustained and in part and dismissed in part consistent with this motion. The initial decision be modified consistent with this motion, and the Office of Special Assistance prepare an order, an opinion and order consistent with this motion.
Is there a second to the motion?
Second.
Seconded by Commissioner Whitmer. Any discussion?
Yes. Vice Chairman?
Huh?
Chairman?
Commissioner Powell?
Thank you. Let's just take this opportunity. This is once again an unfortunate situation that has unfolded. If you look at today's docket, here we have a case with Pennsylvania Gas and Electric, and now this entity known as Blue Pilot. And I think it speaks to the work of our investigation and enforcement group to really get a handle on some of these around the edges actors in the market. And I go back to, and it's a dreaded time when we had to deal with the polar vortex and the steps that this commission had taken to really get a safe harbor in place for consumers. And I look at these two cases and commend both Commissioner Coleman and the chairman, and I think we all would agree, that this sends a loud and clear signal to these two actors, these two suppliers, that if this is the way you're going to conduct your affairs as a retail energy supplier in Pennsylvania, we don't want you here. What we want are suppliers that are offering fixed variable rate, transparency on the website, good marketing practices, and not out there hoodwinking customers. And in this particular case, and my Irish is up here this morning, that this customer took it upon herself to call this entity to not only alert them to the situation, and yes, it's probably a variable rate contract, and ask to be converted over, and this entity didn't even take the time to switch that customer over to the lower rate. That's appalling. And I hope that the message that's sent here this morning to these two companies is that if you don't improve your act, and I've said this before, Madam Chair, we will, and this is not an idle threat, we will revoke a license if this continues. So again, I just want to commend you both for, and all of us today, to really taking these steps, because I can say honestly, we all have the battle scars associated with the polar vortex and the customers that got caught up in this situation. So again, thank you, and I'll turn it back over to Chairman Place, Vice Chairman Place.
Vice Chairman Place.
Alexander Haig.
Thank you, Commissioner Powson. Any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0.
Thank you. On the staff recommendation, as amended by the motion, if there's no further discussion, can we take the previous roll call? The motion passed. The staff recommendation, as amended by the motion, passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of regular agenda items. Turning now to the carrying agenda. And the matters presented on behalf of the Bureau of Technical Utility Services. It is recommended that both items they're appearing, namely the recommendation in the proceeding involving Metropolitan Edison Company, Pennsylvania Electric Company, Pennsylvania Power Company, and West Bend Power Company's petitions for approval of the long-term infrastructure improvement plan, as well as the recommendation in the proceeding involving the ratification of the emergency temporary authority issued to BTS Services, Inc., be adopted by the Commission.
Do I have a motion to adopt the staff recommendations?
So moved.
Do I have a second?
Second.
Motion by Commissioner Powson, second by Vice Chairman Place. Any discussion?
It was Commissioner Coleman, but
I'm sorry. Commissioner Coleman. Motion by Commissioner Coleman. Please correct that record. And second by Vice Chairman Place. Any discussion? Seeing none, all those in favor say aye.
Aye.
Any opposed? Motion passes 5-0.
That does complete the presentation of agenda items.
Thank you. If there's nothing else to come before the Commission at this time, the meeting is adjourned.